Hello. Hello, Bhavna. Am I audible? Yeah. So we start with specific relief act today. And when I talk about specific relief act, you all should remember that this is one of the major amendments in specific relief act which has happened in 2018. So term specific relief means speci. It means that where, for example, A enters into contract with B to perform some work for B or to deliver some goods to B. And if there is a default, the normal remedy is going for damages as per contract act. But here B may seek specific performance of exact work or goods to be delivered to him. That is why this specific relief means speci. So this is a very important relief in civil law because you see a lot of litigation in the lower courts which eventually come by way of RSA also in higher courts and by way of SLP in Supreme Court. So these matters are basically, by and large, they are relating to immovable properties, especially when there are disputes with the sale, whenever there is a dispute of agreement to sale. So when I talk about amendment of specific relief act, before elaborating on that, you all should know that specific relief act originally the old specific relief act which was formulated after partition, that is 1963, that is 1963, uh, it had eight kinds of reliefs. So what are the eight kinds of reliefs we are talking about? First is possession of specific immovable property, that is by virtue of section 5 and 6. Then the second relief is possession of specific movable property, which is by virtue of sections 7 and 8. Third relief which I talk is of specific performance for contract, that is section 9 till section 24. Fourth relief which we are talking is of uh, rectification of instrument, that is by virtue of section 26. Then I further move to recession of contracts, which is by virtue of section 27 till 30. Then I have cancellation of instrument, section 31 to 33. Then I have declaration decrees, section 34 to 35. And at the end, we have preventive relief injunctions, which are from section 36 to 42. So when I talk about specific relief act amendment, so this act was amended in 2018. And before studying the specific relief act, you should understand what are the basic amendments which have been carried out in section 2000 in amendment of 2018. So when we talk about amendments, first let us read section 4 of the specific relief act. It says specific relief to be granted only for enforcing individual civil rights and not enforcing penal laws. It says examples: tort for wrongful death, and second example is inheritance of person murdered by murder. For example, section 25 of Hindu Succession. So specific relief to be granted only enforcing individual civil rights and not for enforcing penal laws. So when I talk about tort for wrongful death, tort is also one of the subjects of law you have read. And especially when we talk about torts, we always talk about nuisance, public nuisance and its domain. We talk about vicarious liability, which is originally described in law of torts. Now, one thing you have to understand that this Amendment Act of 2018 It came into force on 1st October 2018. Wide notification SCO 4888 Clause E dated 19 September 2018. So this Amendment Act, the first question is, whenever we talk about any Amendment Act, the first question which is normally posed to you is whether this act is prospective or whether this act is retrospective. So when I talk about prospective and retrospective effect, I talk about the videos. Sorry, I talk about so when I talk about amendment and when I talk about its prospective and retrospective effect, we have to refer to the latest judicial announcements by Honorable Supreme Court. So when I talk about whether this amendment is prospective, so what do you mean by prospective? Prospective means the day it is amended, from that day, this new amendment will be valid. Retrospective means whatever amendments have been done in this act, they will be retrospective to the previous dates. So in this, I will be giving you a latest judgments of Honorable Court. And that judgment, when I talk about is of Honorable Apex Court. So it says that when I talk about section 10, so we will read section 10. It says the amended provision of section 10 of Specific Relief Act is prospective and does not apply to those transactions that took place that took place prior to its coming into force. So here I will refer the Supreme Court judgment of, I will write down the judgment name so that it is convenient for you. So that Supreme Court judgment is, I'll write down on the whiteboard. So the judgment name is it's Varka Dr. Sujata. It is Katha Sujata versus Siddham Shetty Projects Private Limited. So this is the latest judgment of 2022. You all can take note of this. So moving forward of this aspect, now I will also refer that what are the important amendments which have been carried out in Specific Relief Amendment Act of 2018. First, when you see section 6 of specifically act, so section 6, ambit of section 6 has been widened. So when I say ambit, it means that earlier it is, so section 6 is basically sued by person dispossessed of immovable property. So here there is amendment in 2018 where we say that through whom he has been in possession or any person. So earlier it was only talking about the person in possession. Now it is also vis-a-vis through whom any person is in possession or any person whom he has authorized to be in possession. So this is one of the aspects of amendment. Then section 10 of the Special Relief Act 1963 has been substituted. It is now totally a new section here. So here you should remember that section 10 has been substituted and specific performance of contract has been made a rule. So earlier, what was there? Earlier, it was basically whenever we used to read section 10, so it used to give you the categories in which the court may. So here, the original act provided that it was the discretion of the court to provide for specific performance. But now, by virtue of the Amendment Act, section 10 categorically says that specific performance of contract has been made a rule subject to only the provisions of section 11 clause 2, section 14 and 16, meaning thereby that section 11 clause 2, section 14 and 16 are the exceptions of section 10. Further moving to next important amendment which happened in specific performance was section 14, where it was held that section 14, now again section 14 in the new amendment has been substituted and structured in tune with the amendments made to other provisions. It enlists the categories of contracts which cannot be specifically enforced. So when you see section 14 from your Bayer Act, you will see that here it has categorically said that contracts not specifically enforced. So what are those contracts? So you see there are almost A to D categories. So what are those categories? That we will discuss when we read section 14 in detail. So those four categories are, they are mentioned in their Bayer. So one more thing you have to understand that besides section 14, section 14A has been added. Earlier, there was no provision for the experts, but now the power of court, envisages itself to engage experts. So 14A has been added, empowering the courts to engage experts to seek their opinion in certain matters. Further moving, in section 15, it says, so before section 15, there is a heading, persons for or against whom contracts may be specifically enforced. So section 15 says who may obtain specific performance. So here clause FA has been added where the limited liability partnership has been given the power to seek specific performance after its amalgamation with another LLP, that is limited liability partnership. So limited liability partnership also a new enactment. So you see there are a lot of law firms which are having LLPs. So here also specific performance uh, provision has been provided for this newly enacted statute, that is limited liability partnership. Moving further, we have section 20, we have section 16. Now, section 16 also has been amended relating to personal bars to relief. So, what are the personal bars to relief? So, it says specific performance of contract cannot be enforced in favor of the person. So, what are the specific bars? Personal bars was there was originally a contract and it has been substituted under section 20. So there are categories of it. So what is Section 20? Section 20 is basically substitute performance of contract at the expense of the party, committing breach of contract, committing breach of contract. So this has been added. So it means if the party has done a breach, there are two parties, A and B. So let us say the B party has done the breach of contract. So the other party gives him the chance that okay, you are a defaulter now. So you substitute yourself with a new party, but at the expenditure, and all those expenditures will be carried out by the B party. Then I further talk about Section 20A. 20A has been added, providing special provisions for contracts relating to infrastructural projects specified in the SECJU. So, what are those? What are those categories that you will see in Section 20? So, here 20A says that no injunction in such category of contracts where granting injunction would delay or impede in the progress of completion of infrastructure project. So infrastructure projects, now we say smart cities are coming up and a lot of development is being done by the developers. So section 20 is a very important enactment. It says special provisions for contract relating to infrastructure. It says no injunction shall be granted by a court in a suit under this act involving a contract relating to infrastructure project specified in the schedule. So, what are those categories? So, when you open the DARE Act in the last, you see schedule category of projects infrastructure in subsectors. So, it says there are when you see a DARE Act is provided here, like transport, it says roads and bridges, ports, meaning including capital dredging. So, all these transport. So, basically, there are around uh, five heads of it categories. First is the transport, second is the energy, third is water and sanitation, fourth is the communication, and fifth is the social and commercial infrastructure, in which your sports infrastructure comes into play, hospitals come into play, medical colleges, paramedical training institutes are there, tourism infrastructure, three or higher category classified hotels located outside cities with population of more than 1 million, ropeways and cable cars, common infrastructure for industrial plots, and other parks with industrial activities such as food parks, textile parks, special economic zones, we call it SCZ, tourism facilities and agriculture markets. Then we have post-harvest storage, infrastructure for agriculture and horticulture produce, including cold storage. We have terminal markets, soil testing laboratories, cold chains, including cooling facilities for a farm level pre-cooling, affordable housing, including a housing project using at least 50% of the floor area ratio, floor index for dwelling units with carpet area of not more than 60 square. So here, when I talk about housing, we talk about a carpet area. So carpet area is basically defined in RERA, that is Real Estate Regulation and Development Act 2016. Same meaning as signed to Section 2K of Real Estate Regulation and Development. So when I read these categories and when I go to back to Section 20A, so you come to know that this provision has been amended by the government so that there is no injunction passed against these projects which are necessary for our country because we are a developing country and India is now, because of Chandrayaan, we are one of the, we have also, uh, we have also joined the League of Nations, in the space. So we need massive, we are a part of a progressive society and we need massive progress and development in our country. That is why these amendments were made out. Because you see, one thing you have to remember that law has to be changed. When I talk about law, particularly in our country, if I compare it, let us say to UK, one thing you all should understand, all your main acts like IPC, Evidence Act, CRPC, there has been new laws for this. And when I talk about new laws, let me share something with you on this. I will now give you some inputs on this. Yeah. For example, so there are new bills passed by the, so you all should be aware. IPC name has been changed, CRPC name has been changed, and evidence name has been changed. So I'm sharing a PDF with you, and we'll talk about some basic features of these apps. For example, let's talk about Bharatiya Nyaya Samhita. So when I talk about, so what is Bharatiya Nyaya Samhita? So Indian Penal Code's new name is, so it says Bharatiya Nyaya Sanhita 2023. So it says now this bill was introduced in Lok Sabha on August 11, 2023. The bill repeals the Indian Penal Code. The IPC is the principal law in criminal offences. So you remember that most of our law, Indian Penal Code, Evidence Act, even I say CPC also, they were all written in 18th century. 18th century was age of Stone Age. Now we are in 21st century. So when I talk about, so these changes would have been done. See who changes the law? Parliament. No, no. The Parliament has not done it for so many years. Obviously, law is also depleted. It doesn't hold good in today's time. The best example of the when now you're all now I was taking the interview of the candidates who were selected for Punjab judiciary in one of the academies. So Punjab mein, there is a Rent Act. Now this Rent Act was made in 1937 during World War II. So nobody had, and it was only made for 4 years. Partition happened, and this Rent Act is still going on. So what happened? Parliament never. Now this was a state subject. So rent is a state subject. Now what is a state subject? That is mentioned in Constitution. So see, every state has a different rent law. So here in Punjab, the rent law is of 1937, and nobody has changed it. Only one amendment was done by a Kali government. That is Section 13B. When I talk about NRIs, right, we talk about sum-reliability. Then we talk about personal necessity. So basically, there are five grounds of eviction in rent law. This I'll discuss as and when we do. So the point what I'm trying to tell you that Supreme Court, by way of judicial opinion, has laid down the definition of personal necessity. So this work would have been done by the Parliament by changing the law, by giving a latest rent law to our state. But unfortunately, our state lags far behind in the rent legislation. That is why a lot of multinational companies they say we want a uniform civil code on rent legislation at least. So a lot of questions are coming on uniform civil code. It is one of the topics of mains also. So when I talk about uniform civil code, you should remember that Goa is the only state where uniform civil code is applicable. So IPC is called now Bharatiya Nyaya Sanhita 2023. So all those candidates who are interested in the lectures, they can send me their emails, right? So I can send you some literature or I will share this on my YouTube channel also so that you can all avail of. You can all take the benefit of it. So IPC is called Bharat Nyaya Sanhita. Similarly, when I talk about um, another bill, I talk about this uh, Bharat Nagrik Suraksha Sanhita. So when I talk about Suraksha Sanhita, so it means the Code of Criminal Procedure. So the name is Bharatiya Nagrik Suraksha Sanhita 2028. So you all should know what are the features of the new bill. So this will also I will give you and share it with you guys, at least those who are really serious about it, and others may excuse me on that. Then I have, then we also have latest evidence act. So जब हम लेटेस्ट एविडेंस एक्ट की बात करते हैं, हम बात करते हैं भारत, क्या बोलते हैं इसको, भारत, द भारतीय साक्ष्य बिल 2023. This is the new name of the Indian Evidence Act. So this also I will share with you as and when it is required. Now coming back, so coming now, so so coming back to our original, yeah, yes. So now you see that uh, now after sharing the video, let me now close the sharing.